All right. When you think about the United States and Iran, you probably think of, sanctions, military posturing, all that tension. But what if I told you there's this kind of secret courtroom, one born from a crisis decades ago that's actually still a live option for them to hash things out legally? It's pretty surprising. So let's dig into how that's even possible.
So let's just jump right in with a huge question, one that really gets to the core of international law. Imagine this. A country carries out a military strike. Forget the politics for a second. Is there an actual courtroom where the other nation can legally sue them? I mean, can you really take a country to court for something like that?
Okay, to figure this out, we're going to use a specific scenario from the source material for this explainer. It's a hypothetical U.S. military operation against Iran, and it's got this dramatic codename Midnight Hammer. Think of this as our test case, the thing we'll use to try and find a path through this pretty complex maze of international law.
All right, so where would you even take a case like Midnight Hammer? Now, when you think about countries suing each other, there's one place that probably pops into your head right away. But, as you're about to see, the most obvious answer is actually a total dead end. And yeah, that place is, of course, the International Court of Justice, the ICJ. You know, the World Court. It's the main court for the UN, so it just seems like the perfect spot, right? But for the US and Iran, nope. It's not nearly that simple.
See, the whole problem with the ICJ boils down to one simple thing: consent. For the court to hear a case, both countries have to agree to show up, and in this situation, they just don't. The U.S. actually pulled back its general consent to the court's power way back in 1984. Iran's acceptance, it's super limited. And that one treaty that could have maybe forced them both to the table, the Treaty of Amity, that got terminated back in 2018. So, to put it simply, the World Court is out. It's a non-starter.
So, if the most obvious path is blocked, where do we go next? Well, our investigation leads us somewhere way more obscure. We're about to uncover this really unique tribunal, a special court that was literally born from one of the biggest international crises of the last century.
The story starts back in 1979 with the U.S. Embassy hostage crisis in Tehran. To finally bring that crisis to an end, the U.S. and Iran hammered out a deal in 1981 called the Algiers Declarations. And this agreement did more than just free the hostages. It created something totally unique: the Iran-U.S. Claims Tribunal. And here's the crazy part. It is still running today, out of its office in The Hague.
Now, at first, this tribunal was just buried in all these private claims, from companies and people caught up in the revolution. And yeah, most of those cases are done and dusted. But, and this is a huge but, a special part of its job is still very much active, handling disputes between the two governments themselves about what the agreement means. These are called A cases, and they are the absolute key. They're a direct line for Iran and the U.S. to actually sue each other.
Okay, so if this old tribunal is the secret venue, what line in that 1981 agreement actually gives it the power to handle a case about a modern military strike? Well, hidden right there in the text is a very specific promise. It's basically the legal smoking gun, and it's just been sitting there, waiting for more than 40 years. Here it is. This is the sentence. It's from point 1 of the General Declaration, signed back in '81. Listen to the wording here. It's so important. The United States pledges that it is, and from now on will be, the policy of the United States not to intervene directly or indirectly, politically or militarily, in Iran's internal affairs. Did you catch that? It's not just a nice thought. It's a pledge. And it specifically, explicitly calls out military intervention.
But wait, you might be thinking, couldn't the U.S. just argue, hey, that was just a policy statement, not a legally binding rule? Well, the case against that argument is actually really strong. First off, you use the word pledge. That's a powerful word. It's a firm commitment, not just a vague intention. Second, think about this. The agreement itself gives the tribunal the power to rule on this exact point. Why would you do that if it wasn't a real enforceable obligation? It wouldn't make any sense. And really, all this pledge did was put into writing a rule that was already a basic part of international law. You don't intervene in other countries' internal affairs.
So up to this point, we've been talking about our hypothetical Midnight Hammer. But this is where our whole story takes a huge turn into the real world. Because it turns out, this isn't some theoretical legal brain teaser. Nope. This exact clause has already been put to the test.
Just one number, 1996. What's so important about 1996?
Because in 1996,
our whole hypothetical suddenly became very, very real. Iran went ahead and filed case A30 at the tribunal. And guess what they used? That exact same non-intervention pledge we just talked about. They used it to sue the United States for alleged covert activities. So this isn't theory anymore. This is precedent.
So, what happened with that case? Did they argue it out? Well, the U.S. filed its defense in 1997, and that case is still pending. Today, it has just been sitting there on the docket for decades. So yeah, this legal path is absolutely real. But man, it moves at a truly glacial pace. So where does all this leave us? I mean, what does it all mean? We started with a simple question about a military strike and finding a court. Our search took us away from the obvious answers and led us to this completely unexpected place, a kind of relic from a past crisis that is, almost unbelievably, still alive and kicking. And that's really the big takeaway here. This Iran-U.S. Claims Tribunal, it's what you might call a living relic. It's not some dusty footnote in a history book from the 80s. It is an active legal battleground. It's one of the only places on Earth where these two nations still formally argue their cases. It's this bizarre tool for the future, built in the past, that operates on a timeline measured not in years, but in decades. And that leaves us with one last, kind of deep question to think about. When a path to justice takes this long, decades, does it change what justice even means? Is a legal process that outlasts generations of politicians a powerful tool for holding nations accountable, or is it just a symbol? A sign that international justice operates on a whole different plane of reality? Something to chew on. Thanks for joining me on this one.